poppin', people? Welcome to another journal entry at IDW Deuce. I know you see your boy, man. Your boy came up a little bit, got better lighting. Nice new background. Truth be told, wifey kicked me out of the bedroom. She's tired of me making videos in the bedroom. She's allowing me to use her office. So, I guess I came up. I want to talk to you about asset protection. Now, I know you saw the thumbnail. It said, how do I get my property out of my name while I still got a mortgage? Don't worry, I'm gonna get you there, just trust me. But I have to tell you about some tools before I can tell you about the strategies. You wouldn't want to use a saw when you really need a hammer, right? Alright, cool, so just let me do my thing. I'm gonna get you there, don't worry. First thing I want to talk to you about are wills. Now, what are wills? Wills are documents that are going to dictate how you want your affairs handled in the event that you pass or are incapacitated. These are things like advanced healthcare directives, which are living wills, which are going to tell people, I don't want to be in a vegetative state. I don't want to be kept alive on artificial means. I just want to move on. An advanced care directive is something that's going to state that. They're going to state your wishes, what you want to do, and they're going to be executed as such. Same thing with the child protection plan. You want to dictate who you want your children going to. If you want them going to a loved one, do you want them to go to a friend? A child protection plan is going to state directly, okay, this is who I want my children to be taken care of, and it can also list the resources that that person will have access to help take care of your children. Also, you want to have things like financial or medical power of attorneys. Now, these are documents that are going to give a person the right to make decisions on your behalf in case you are incapacitated or when you pass away, because there may be challenges. Somebody might not agree with your wishes and they want to challenge. If the person that you have in charge of your affairs has a medical or financial power of attorney, then that's it. That gives them the legal backing to make those decisions as you see fit. Why am I talking about these things? Because you want to have all these things in order. If you're incapacitated or you pass away, you don't want to leave that burden for your loved one. You want to allow them to grieve and you want them to heal. You don't want them worried about making these decisions that they may not even know what you want. But if you have everything in place for them, there's no question marks. Everything is done, everything is set, everything's written down, and all they have to do is honor your wishes, and then they'll be able to grieve and heal. And that's what we want for our loved ones if we would pass away. I know this is a subject that a lot of people don't want to talk about, but honestly, it's really necessary, because if you don't do this, you can leave your people in a bad situation. That's the last thing you want, because that's just compounding things on top of things. Now, with wills, the one thing you have to keep in mind is they don't go into effect until you are actually incapacitated or you pass away. Now, let's talk about trusts. Now, trusts are used for asset management. Now, you might be thinking, okay, if I have a will, why do I need a trust? Well, there's certain things you'd rather have handled in a trust than in a will. If you have your assets distributed through a will, what's going to happen is you're going to have to go through the probate process. Now, what is the probate process? Your loved ones are going to have to go to court to get your assets. They're going to have to go see a judge, which means they're probably going to have to hire a lawyer, which means more money. Money they may not have. You may have money dictated in the will, but you're not going to have access to that until after the judge rules. So your loved ones are probably going to have to come out of pocket. Again, that's not something that you want. So a trust is a tool that you can use to bypass the probate system. You're able to do that because a trust will have a trustee who is in charge of distributing your assets based off the documents within the trust. Now, you want to have someone you can trust managing your affairs, of course, and also dealing with wills and trust. You want to make sure you seek legal counsel when putting these things into place. The good thing about a trust versus a will is a trust is in play as soon as you sign the document. You don't have to wait until you pass away for you to put your assets into a trust. Now, this is what you came here for. You can put assets into a trust, i.e. your property. If you have valuable items like sneakers, I told you I had a sneaker addiction, right? You're able to put your property into a trust. You might be asking, okay, if I have a mortgage, how can I put my property into a trust? Because there's a such thing as a do-it-on-sale clause if my deed is transferred to somebody or anybody or anything. Well, hold on. There's an act called the Garn and St. Germain Act that says that you are able to put your property into a trust as long as you are the trustee or beneficiary of that trust. See, There you go. That was the answer that you were looking for. Now, putting your properties into a trust doesn't mean that you give up your occupancy rights. You are still able to occupy the property. You still have control and are able to manage that property while it's in the trust. It's just that it's not in your personal name. It is in the trust. Now, this is a good tool to employ, especially for people like me that have assets in multiple states. I know a lot of my people in the military can understand that you move around, you might accumulate assets here, you got an asset in this state, you got an asset in that state. You can put them all into a trust and you don't have to worry. If you leave your properties in a will, what's going to happen is each state that you have a property in, you're going to have to go to court in each of those states, meaning your loved ones are going to have to hire lawyers in each of those states to take care of those properties in those states. Now, if you put your properties into a trust, you don't have to worry about that. Everything is passed down through the trust, avoiding court, no lawyers. Only person you're dealing with is the trustee. Hold on, there's still more. Property is not the only thing that you can put into a trust. You can put other assets into a trust. You can put your LLCs in a trust. You can put a life insurance policy into a trust. Now, why would you want to do that? Well, there are a number of reasons why you want to do that. There are strategies that you can put in play if you use a life insurance policy to fund your trust. For instance, in the event that you pass away and your life insurance policy cashes out, that money goes directly to your trust and you can use it to pay off your properties. Now, you're leaving your loved ones, your beneficiaries, with debt-free assets. Also, it is a good tool to start generational wealth. Say you have young kids and you pass away. The money from that life insurance policy could be used to be put into a 401k until your children become of age and they are given access to that money. Now, if you put 500k into a 401k and it's in there for 10, 15, 20 years, I mean, I'm no math major, but that's a lot of bread. I mean, let's do a little recap. A will is a document that goes into effect after you pass. It's good for dictating your wishes on how you want things handled, like your child's care or your advanced healthcare directives, but it's not something that you want to have distributing your assets. For that, you want to have a trust. You want to have a trust and a trustee who distributes your assets based off your wishes in the trust. You can use a life insurance policy to fund your trust. You can pay off your assets, you can invest the money, or you can just allow them to cash out the policy. The point of it is the trust gives you control. You dictate the terms of your trust. Now, there are two types of trust. There's a revocable trust and an irrevocable trust. And it's exactly how it sounds. Irrevocable means it cannot be changed. Now, this is usually good for tax purposes or for lawsuit protection. Because like I said, it can't be changed. So somebody can't sue you because the trust is already established and changes cannot be made. Now, a revocable trust is something different. You're able to make changes throughout your lifetime. A living trust is something that you want to have because things change, the situations change, friendships change, relationships change. So you want to have something that you can also change. You can take people out, you can put people in. You can take assets out, you can put assets in. You can change who you want them to go to. The point is you can make changes to this document and that's what you want. Now, a will is going to be more cost effective than a trust. A trust is very detailed and there's a lot involved. If you're going to put properties or LLCs into a trust, obviously it's going to cost some money. It's going to be expensive, but it's a lot less expensive than the money that's going to be coming out of pocket from your loved ones when they can't get control of your assets because they have to go through the probate process. So that's it in a nutshell. I appreciate you walking this journey with me. If you found any value in it, please like, share, and subscribe. Also hit me on my IG, IDW__INC. I have a lot of fresh content out there. I'll also give you some drops of some real shit. That's my hashtag. Be on the lookout for it. Again, I appreciate you walking this journey with me, and I look forward to building with you. Deuces.